impeachment proceedings against Judge Nkola Motata and Judge John Hlophe are all set to go ahead. And this after Parliament's Justice and Correctional Service Committee had agreed on the framework to start both processes. Now, Judge Motata was found guilty of misconduct following a 2009 drunken driving incident, and the Judge Hlophe matter relates to alleged attempts to influence Concord judges in pending judgments. So to unpack this even further, I'm now joined by Prof Mia Swart, visiting professor at Wits Law School. And Prof, thank you so much for your time and a very good morning to you. Good to have you. I mean, what happened perhaps in the week that was in terms of the ongoing impeachment proceedings involving both judges in your view?
Well, finally, we're seeing some progress in this matter. You know, it looks like things are finally moving closer to a resolution after all these years. So this week, what was significant is the matter has now moved to Parliament, because under Section 177 of the Constitution, it's Parliament that, you know, should ultimately vote on the impeachment. So this week, the Justice Portfolio Committee has essentially taken charge of the matter and come up with a framework for the procedure for the impeachment, because this is such a novel thing. You know, there is no procedure as things stand at the moment.
Yeah, and also perhaps we can delve deeper into that role by Parliament in terms of this impeachment process.
Yes, what's very interesting about this impeachment process, which distinguishes it from the impeachment process of, for example, the public protector, or possibly, you would remember in the Zuma years, there were all those attempts.
Yeah.
But what's different about this one is Parliament is not allowed to get into the merits or the substance of the matter. So they this week set out a very clear 6-stage process that they have to follow. In essence, what's going to happen is, well, Parliament, as the overseer of all public power, and that has, you know, this constitutional role to see that public power is exercised correctly, Parliament is now going to note that, you know, they've received a report from the JSC that there's been gross misconduct. The next step is that the JSC will make formal representations to Parliament. But again, Parliament will not go into the substance of those representations.
Yeah.
And then both judges will have a chance to, you know, present mitigating circumstances. The interesting question is whether there will also be a chance for aggravating circumstances, but it doesn't look like that at this point. And then there's 3 more steps, which essentially just involves the Justice Committee deciding on whether there'll be a vote. And that's the big question. So that important question is now in the hands of the Justice Committee. And if there is going to be a vote, it's going to require a 2/3 majority of the National Assembly. So, you know, this is the big question, is whether it's going to go to the point of a vote.
Yeah, I mean, Prof, I mean, this is quite uncharted territory, right? We haven't really seen a judge been impeached in the country.
Yes, actually, it's interesting. There was one other instance in 1898. President Paul Kruger, he impeached a judge, Judge Kotze, for making this sort of terrible statement that law should be tested against the Constitution. And this President Kruger didn't like, and he impeached him. Yes.
And what makes it so interesting is that it's 2 judges, 2 separate incidents, but I mean, one is one too many, because we would like to believe that our judges uphold, you know, the law. Take me through the seriousness and the nature of how serious these 2 cases are, especially at the level where they are today in impeachment processes.
Yes, we know that, you know, just after the complaint was made against John Hlophe, who was such a senior judge, you know, he was the judge president of the Western Cape Division. He then goes to 2 Constitutional Court judges in their chambers and tries to influence them. This universally would be seen as gross misconduct. And the Cape Bar Council reacted immediately and said, you know, they hope that this will be dealt with by the JSC in serious, you know, terms. And the Law Society said it should be dealt with expeditiously. Here we see about 16 years later that it's still not been dealt with, you know. And the SCA in June this year rapped the JSC over the knuckles for being too soft on Judge Motata. The JSC, I think, you know, is a bit culpable in not moving these matters forward more swiftly, and not really emphasizing the severity. Because we know what happened to Judge Motata was he was simply given a fine, you know. He was held guilty of misconduct, not gross misconduct. So misconduct isn't impeachable. He was, kept on his judicial salary, which cost the taxpayers many millions of rands over the years. So, for a long time, it was simply not dealt with seriously enough by the JSC.
Yeah. And why do you think, Prof, there's been that delay when it comes to this impeachment process?
Well, I think certainly in the case of John Hlophe, he's a very interesting case because we know that he was quite close to ex-President Zuma and, he might have taken some notes about the sort of most efficient way of using the courts to stretch out one's case. Certainly that sort of Stalingrad technique applied to him as well. And I would say in the case of Hlophe also, he was seen as, a very promising, young black judge joining the judiciary. He was, really respected initially. So I think it took a long time to really understand his tremendous fall from grace. And then I think there's also been some political maneuvering behind the scenes. And also, frankly, I definitely think that there's been some misuse of the term racism. He started accusing people of racism, even, people like Pius Langa, which was quite absurd, just to sort of win some time and try and improve his case, but he actually harmed it.
Yeah. I mean, in my previous question about, us not seeing a judge being impeached in this lifetime, certainly the precedence was probably set back in the 1800s. But for this particular impeachment, what precedence exists here forth, do you think?
There's nothing in this country, I think that we have been quite good about appointing judges that upheld the law. So, of course, the main task of the JSC is to appoint judges, that are unbiased, that have integrity, and all of this has been taken very seriously over the years. At the moment, it's interesting that in countries such as Kenya, there are more instances of judicial impeachment, and this is something that should be regulated, very firmly. So it's good that this week, we've seen some progress in terms of at least having a definite framework in place.
All right, we'll keep a close eye on this particular case and impeachment process. But thank you so much, Prof, for coming through and speaking to me right here on Newslink. Professor Mia Swart, visiting professor at Wits Law School. Just following through with, of course, the case involving both judges, Judge Hlophe and Judge Motata. We know there have been quite a number of delays, but of course, Parliament now continuing on with that process. We'll keep a close eye and update you right here on eNCA.